Okay, so Attorney Salinger, whenever you're ready.
Thank you. Good morning, may it please the court. My name is Seth Salinger. I represent the appellants, Lantern 18 and Sam and Marcia Bergman, and with me today is my associate who's also on the briefs, Studi Venkat. When I was retained to appeal the decision on summary judgment in this case, I thought this was a garden variety promissory note case. I still think it's a garden variety promissory note case. But obviously, there are unique circumstances here that got the SJC's attention since this court took it up directly from the appeals court. And I think one of the difficult issues here is that the defendants are obligors on a promissory note, which the Superior Court said was an instrument that provided for one obligation and one obligation only, and that is to pay money. And that is true. But what the appellants have tried to argue is that because of the unique circumstances of the governor's COVID-19 emergency orders that essentially, not essentially, did in fact prevent my clients from performing the cleaning services that generated the revenue that enabled them to pay on the note.
Isn't that the nature of a personal obligation? So if I have a landscaping business and I want to buy a backhoe, and the bank won't give me money as Gaziano Landscape, but they'll make me a personal obligation. If my landscape company goes under, I'm still on the hook, correct? To pay for the backhoe? That's why they want my personal obligation, not the Gaziano Landscape and Inc.
Well, that's true. So it's interesting because the appellee points out that the Bergmans are co-obligors on the note. I would submit what they really are is guarantors.
Right. I think that you hit the nail right on the head. They're guarantors. And guarantors need to pay up when the obligor does not, regardless of circumstances. Isn't that the whole point of a guarantor?
The point is that if an underlying note obligation is deemed either unlawful or unenforceable, or the obligations of that note are suspended, then concomitantly the obligations of the guarantor should also be suspended.
What is your legal authority for that proposition?
What is the legal authority for that proposition?
Yeah, that a guarantor is off the hook when the obligor is off the hook. It
Well,
doesn't seem to make sense.
I think it's standard law that if a note is discharged, then the guarantor's obligation is discharged. So it's discharged if it's suspended. That's what we're saying, that under the very narrow circumstances of this case and for a very limited period of time, and only applying in very extreme circumstances where there is an emergency with an attendant government edict that affects the entire economy, for that period of time, the note should be suspended and the obligations of anybody who's obligated under the note should similarly be
So
suspended.
any borrower is off the hook and any guarantor is off the hook during COVID-19?
Well, we have examples, for example, of the CDC issuing eviction moratoriums. We have examples of banks reformatting mortgages during COVID. We have examples of landlords acquiescing to tenants saying, I can't pay, and either suspending lease obligations or rewriting leases or letting commercial tenants out of leases. Probably millions of dollars in this country over the last 2 years were not paid to commercial landlords because of that very reason. So yes, there are emergency situations where commercial paper gets reformed either by operation of equities in the private parties agreeing to do it, or sometimes by the executive branch reaching down into a private contract
But we don't
and
have-
So here,
readjusting
we
it.
don't have any of that. We have neither the private parties agreeing as an equitable matter to discharge the obligation, nor do we have any sort of legislative or agency action suspending the obligation.
That's
You're
cor-
just saying that as a matter of law, the court should come in and suspend the obligation.
I'm
by-
saying,
And so my
yes, as
question
a-
was, what is your legal authority for that proposition? That we as the court can come in to do what the agency, the legislature, and the private parties decided not to do?
Well, courts do this. Courts do rewrite, for example, covenants not to compete, or they did prior to the enactment of the statute, which severely limited the applicability of that doctrine. Courts have rewritten contracts throughout our jurisprudence. That's why we no longer have caveat emptor. That's why we now have an implied covenant of good faith and fair dealing. All of these things arose because court said the letter of the contract says what it says. Nobody disagrees with that. In this case, nobody disagrees with the fact that the promissory note has an absolute obligation and that there's an acceleration clause. The appellees seem to be arguing...
And it doesn't have a force majeure clause.
There's no force majeure.
It's a really draconian but very clear contract saying you got to pay up. There are no excuses. There's no force majeure. There's nothing out there like to provide leeway, is there?
That's correct.
So isn't that the intention of the parties?
Well, you know, typically, I think one would expect to see a force majeure clause in a services contract.
Right. I mean, and isn't that important? Because you would expect a force majeure clause. Particularly, this is a real contract. It's not drafted. It's not an internet type of contract.
Well,
lawyers here clearly have drafted this thing. There's a lot of thought in it, right?
I assume that my brother drafted the contract. I don't know. I didn't participate. But my point is that I've never seen, frankly, a standalone promissory note. By the way, I don't believe this is a standalone promissory note because this note, even though it doesn't reference the security agreement or the asset purchase agreement, is clearly given only because it was incidental to the purchase of a business. But even if we look at it in isolation...
But it doesn't have one of these clauses that say, okay, if the profits aren't what you said it was, we renegotiate, or doesn't have a force majeure clause. We're doing this, but we need to be paid promptly, or we're going to impose interest and penalties and acceleration. It's just hard to discern. That was the intention, and you're trying to shift the risk now back to the seller, it looks like, of COVID.
Well, I'm not trying to shift the risk. What I'm saying is there's an unforeseeable circumstance that neither party could have contemplated, and particularly in a promissory note situation where one does not expect to see a force majeure clause, because typically those clauses arise in contracts that have to do with the delivery of goods or services that could be interrupted because of a supply chain problem or a war or something like that. Nothing like that was contemplated here. Neither party contemplated it.
Has any appellate court in the country rewritten these types of contracts because of COVID?
I'm sorry, I didn't quite hear.
Sorry, has any appellate court in the country rewritten these types of promissory notes or contracts because of COVID? I saw there are a couple of citations to district court decisions, and there's your namesake's opinion, the Salinger Superior Court decision. But is any appellate court ruled the way you want us to rule in the country?
I don't think so. Not that I can discern.
How do you fit into the doctrine of frustration of purpose or impossibility, given the Chase standard and the facts of that case?
Again, I understand that
Well,
The
first,
problem for
are you relying on those two doctrines
the frustration of purpose,
and/or possibility?
I would say more impossibility than frustration of purpose. It is that the borrowers here, they're not really the borrowers, again, I think they're the guarantors, are a husband and wife, and they are the business. And both counsel at the preliminary injunction made this point, that these are two husband and wife businesses. And so to try to pretend that somehow the LLC is separate and distinct from the husband and wife for purposes of being able to perform doesn't really confront reality. If the LLC, which is...
Isn't that the purpose of the LLC, to kind of avoid that reality?
I'm sorry?
Isn't that really the purpose of the LLC, to sort of avoid that reality?
The purpose of the LLC to be a separate juristic person?
Right.
Absolutely. But it's also a fact, it's a truism that they are the LLC for all intents and purposes. So if the LLC can't perform the services and can't earn money, they can't earn money. You know,
You're trying to pierce your own corporate veil.
I'm sorry?
You're trying to pierce your own corporate veil.
When it assists my argument, yes. The
creditors of the
you know,
LLC can all go after your clients personally. given
well, I mean,
I just
what
want to
I'm-
make sure you're clear as to what you're articulating.
what I'm saying here is that we're confronted with what I would consider to be sort of a Dickensian result. Neither party here did anything wrong. Not suggesting that Lafort doesn't have the rights that are articulated in the promissory note, but we have a situation that unloaded on the parties, as a result of which one party is now facing the prospect of being sent to the poorhouse, and the other party is set with the prospect of getting a windfall through, because they can foreclose now.
Counsel, could I just push back on that a little bit? Justice Kafka made the point about there's no force majeure provision in the promissory note, okay? So prior to entering this promissory note, this contract, they had the ability to negotiate back and forth, and they did not negotiate for that benefit. Your clients did not do that. Let's say after, not some global pandemic, not some war, let's just say all of your clients' contracts after signing this dissipated, and they weren't making any money simply because nobody wanted to hire them. Are you saying that they would just be excused from making the payments under the promissory note?
Not under that, no, not under the hypothetical that you raised, Your Honor.
But you started off by saying they couldn't earn money. And that's because, for whatever reason, I know you're saying it's the pandemic and the executive orders, but the crux of your argument is they couldn't earn money to pay the note.
But there's a difference between a general economic downturn or poor business decisions that result in a debtor's inability to earn money to pay back the lender. That's distinct from what the courts refer to in the frustration of purposes cases and the impossibility of defense cases as a supervening event.
Sure.
That is the distinction. Had it not been for that, there would be no argument. Had Lantern 18 simply been unable to earn revenue through some other circumstance, not having to do with a circumstance over which nobody had any control, we wouldn't be here. There would be no lawsuit. The Lafort would have the absolute opportunity to foreclose, to accelerate, and I don't know that Lantern 18 would have any defense, even one, such as in this appeal, that is essentially based on no precedent.
Mr. Townsend,
Counsel-
before you run out of time, is there any distinction in the analysis as it relates to the acceleration clause?
Is there any?
Difference in the analysis, in your view, as it relates to the acceleration clause?
I'm not quite sure I
So
understand.
in other words, the guarantor, that's why you have a guarantee in case something goes wrong. But the guarantee wasn't just for the money, the contract also provided for acceleration. Is there anything in your view of the case law or the analysis that we should look differently in whether or not the acceleration clause can be enforced?
I'm still not quite following. I mean, the,
Can I follow up and just to maybe flesh that out a little bit? I think Justice Lowy is saying, does acceleration change things? What seems inequitable here, if there is something inequitable, it's the acceleration, that all this money is going to come due. It would be one thing to have them catch up, and they got the emergency loan and they could catch up. But the acceleration changes everything. Isn't that the real harm to your client? Is that
yes,
so I
because,
think- so-
and the
so I have
record,
same
and the
focus
record,
that
I'm sorry,
Justice
Your Honor.
Lowy does, which is the analysis different when the company tries to use the acceleration clause? Is there something we should look at differently there?
Well,
And is there any law to support that?
again, the strict interpretation of the contract gives the lender here the right to accelerate. We're not suggesting otherwise. Every promissory note has an acceleration clause. What's different here is that these events occurred after 5 years of uninterrupted note performance, and they occurred after there were attempts to offer cure payments, which were rejected. And,
But, and I,
It's no.
I'm sorry?
The answer is no. There's no different analysis. That's what you're saying. It's a windfall for the, we're trying to find out if there's some case law argument that you have helpful to you that says it's a promissory note. They got a guarantee. That's why you got a guarantee. You got to pay. But whoa, all of a sudden we got to pay everything? We're trying to find out from you if there's any different in the analysis relative to the acceleration clause. It's a simple question. The answer evidently is no. That's fine.
You may want to think about that.
I don't think that I have, I think I may have a case, but I can't highlight it for you, in the time that I have remaining.
Can I push you a little bit? Because this may be the most important question we're asking you. So if we seem in Massachusetts to treat acceleration clauses just like liquidated damages. We don't look at subsequent events. But COVID makes the acceleration clause tough as a matter of equity, at least. I mean, they may be churlish that they're not, that they're pushing the enforcement of this and they're getting, a windfall from it. But is there a legal basis for us to say, because of COVID, it's not proper to enforce the acceleration clause here?
Well, if you balance the equities, the avoidance of the acceleration clause simply means that the lender gets put back in the position that it was prior to the cessation of payments. The flip side of that is that the borrower loses everything. So if we're balancing the relative prejudice, the relative harm, what we're saying is the temporary suspension of payment does not work an undue prejudice on the lender.
Is that, again, we're looking for a legal basis. Is it a violation of the covenant of good faith and fair dealing?
I think it is.
Well, but you don't argue that. So how do we?
Well, the problem is that it rises in the context of settlement discussions, most of which were, some of which were broadcast to the Superior Court, but most of which could not be for obvious reasons. So again, I think you have to look at this in toto, that this happens after 5 years of note performance, and suddenly a couple of months of non-payment means that the debtors are out of luck and they lose everything. When they did attempt to cure, by the way, there's no opportunity to cure in the note either. The lender doesn't have to accept cure payments. The lender can just say, I took $360,000 of your money, and now I can take the business back because you missed a couple of months because I'm going to accelerate. I don't have to accept your cure payments.
What is the business, by the way? I don't understand what the collateral is. I mean, is it the brooms and the Cleaning fluid?
I mean, probably it's $10,000 worth of mops and cleaning fluid, and the rest is probably goodwill and a customer list. It's not I don't think that there are significant tangible assets, but it was based on that, it was a significant purchase price, and there's a significant indebtedness. I don't think that my client should have to file for bankruptcy or mortgage their house under the circumstances of this case. So, and the lender here, not really a lender, the seller, would not have suffered any undue prejudice to wait, I believe it was 5 days for an SBA loan to come in that would have brought all the payments current. Rather than waiting the 5 days, they filed suit and ran into court and sought a preliminary injunction. Yes, I think that's unfair.
Yeah, but unfair is not law. You're not turning any, what do we look to? Do we look to anything to support that, or we just say, as the trial judge, motion judge said, they should have renegotiated the contract, but they didn't have to?
When were they going to renegotiate the contract? The problem had already manifested.
Okay,
There was no time to renegotiate.
You're not helping us with
Yeah,
anything.
okay, I think we'll stop there.
Thank you, Your Honors.
Okay, Attorney Engel.
Good morning, Your Honors. May it please the Court, my name is Stuart Engel, and I represent the plaintiff and appellee in this case. The one thing I would agree upon with my brother counsel is this is a garden variety promissory note transaction.
Except it happens during COVID-19, where there are these emergency orders. Why is it equitable to allow your client to suddenly accelerate the payments when, as your opposing counsel says, it was a matter of waiting 5 days?
Well, respectfully, Your Honor, 2 points on that. One, it wasn't a matter of waiting 5 days. The record will show that my clients did not file suit until the note was 4 months in arrears and after a good amount of discussion between the parties. Second of all, this acceleration provision, which, as Your Honor knows, is standard in every promissory note that I've ever seen of this nature, was not respectfully an unjust enrichment or windfall. And in fact, the case law is clear that if the parties negotiate this as part of an underlying contract, that the debtor, the three co-obligors in this case, cannot claim that an acceleration provision that they negotiated in good faith, and I might add negotiated twice. The original transaction was in 2015 when my client sold the business, and then in 2018, the co-obligors at that time wanted to extend out the payments further so that they could lower the monthly payments, and a new set of documents was again negotiated through counsel, and that provision was included. The other point I would make, and I think it's important in the context of this, is that we're talking about something that happened 2.5 years ago. The governor's restrictions were lifted thereafter, and in point of fact, had the co-obligors simply paid off the note, they would have been done 5 months ago. So to the extent in the anticipation of a
I'm confused, but the argument is they don't have the money to pay it off. They have the money to catch up.
Well,
but they don't have the money to, the acceleration causes the killer, right?
well, I would respectfully disagree with that. You're making an assumption that they didn't have the money to pay or catch up. As the Superior Court judge noted in her decision allowing the summary.
How much was the acceleration cause? It's being pushed forward 2 years,
It was
right?
26 months of payments and then a final balloon payment.
Give me you know the number. What's
It
the
was
number?
approximately $265,000.
So 260, this is a small business, this is a maid service. You're asking them to come up with $265,000 2 years ahead of time? I mean, it's reasonable to infer they probably don't have the cash for that. That's
Well-
why they negotiated this kind of deal. So tell us why during the COVID changes things. Elderly people don't want people in their homes. Other people who have health issues don't want people in their homes. All of us didn't want people in our homes. Is there any, I'll ask you the same question. Any appellate courts decided this the other way that you're aware of?
No,
Any appellate courts decided it your way that you're aware of?
yes, Your Honor. I shouldn't say appellate court. Mortorano,
A very different case.
the
That's
appeals court here decided. I would also reference in my supplemental brief.
I mean, it seems odd to me. This is a societal issue, and we don't have one appellate case yet? We're the first court to deal with this issue?
With respect to the narrow issue as you posed on the acceleration provision, I would.
Or how about just any appellate court dealing with these types of promises to pay? Do we have any decisions yet?
I do not, Your Honor. The closest thing I have.
You
and
researched it?
I have. And the closest thing I have, I attached to the supplemental brief a decision, a very well thought out decision on a case that is some very close analogous to this case that the U.S. District Court in Chicago
I read that case.
issued 2 weeks ago. And it's an interesting parallel to this case whereas, the performance by my client, as in that case, occurred 5 years earlier when they sold the business. What distinguishes the case that everybody relies on with the Cafe Nero case here and other cases is that performance was ongoing. That the essence of a lease. Or for example, if the cleaning business had contracts with a commercial building or a residential building or customers, and it was the performance by both parties was ongoing and could not have been performed. That's not the case here, and it's in fact not the case in the decision that I attached to.
That's a little tricky though, because I mean, I don't know if the Nero case is decided correctly or not, but the difference, clearly the ongoing nature of this business was important to the payment of your client. So it's not as if this is an abstraction. I mean, there was sort of a built-in assumption they're going to continue to run this business, wasn't
Well, it actually isn't an important assumption. My client performed, they sold the business. As the Superior Court judge correctly pointed out in her decision allowing the summary judgment, a lender doesn't care, and I use that term in quotes, where the money is coming from for the payments, whether it's from revenues, from savings, from inheritance, from anywhere else. Respectfully, the court makes an incorrect assumption when they assume that the two individual co-obligors did not have the funds or the means or the assets to make the payments. That's nowhere in the record, and I would respectfully suggest it's not the case in actual fact.
Step back from month to month. Obviously, we're interested in the acceleration clause and the questions that were posed at the end of the argument to Mr. Salinger. In your research, even putting COVID-19 aside, is there, you mentioned that promissory notes have acceleration clauses. Is there any case or any doctrine anywhere, in any circumstances that you're aware of that's differentiated the analysis for the money in default as opposed to the acceleration clause?
There is not, Your Honor, and in fact, I didn't mention in my brief, but as the court is well aware, in Metropolitan Life Company versus Cotter, and more recently the appeals court in Zelby Holdings, stated that the concept of unjust enrichment, or a windfall, as my brother counsel referred to it, is not applicable where there is a valid underlying contract that defines the obligations of the parties. This isn't simply my clients draconianly, saying we want all our money up front, because you missed 4 payments. This was negotiated twice. This was drafted by lawyers twice. The 2 individuals who are co-obligors, meaning they're jointly and severally liable, were obligors for a reason. This isn't simply, to answer your question, the reason that there is no appellate decision that distinguishes between simply the obligations under the note and the acceleration clause is because in this case in particular, they were all negotiated in good faith.
But that was all before COVID. You seem to be ignoring the fact that we had this, worldwide pandemic. And the fact that it was negotiated before COVID doesn't make it it doesn't change the fact that your clients did say, yes, we want to accelerate this and we want all that money right now.
Well, it's not that we want all the money. It was the money
It was negotiated.
that they were entitled to
because
under the terms of the note.
That
They
was
sold
negotiated before COVID.
Well, if Your Honor were to apply that logic to all acceleration provisions, any time that there was any intervening event, you would open up the type of Pandora's box that would not only undo, well-established, commercial banking law, but you would create a situation, for example, if you had 2 spouses who were co-obligors on a note, and there was for example, consistent with the Mortorano case, if one of them got COVID or got cancer or was in a car accident or some intervening act occurs, that individual, that entity then says, we can't perform under the circumstances.
Yeah, I'm not saying that we should apply it to everything. I guess I'm just referencing the motion judge's comment that it's a shame that your clients couldn't figure out a way to resolve this.
Well, without discussing things that are not part of the record and would be privileged in nature, the record does reflect that there were offers, plural, and attempts to resolve. That simply did not work out. And there are other reasons, based upon the history of the relationship between the parties, that did not occur for reasons
Counsel, can I ask you on the doctrine of impossibility, has there ever been a case that you're aware of that applies that doctrine where performance is complete by one side?
Not that I am aware of. The doctrine of impossibility in a case like this, there would have to be something that would show that the entire substance, nature, and purpose of the transaction between these 2 parties was destroyed, to use that word, I'm not sure it's the correct word, as a result of this event. And the fact of the matter is that is not what occurred here.
But have you researched whether the doctrine has ever been applied in a situation where one party's performance is complete?
I researched the issue, and not that I am aware of. The case that...
And what about the doctrine of frustration of purpose?
Again, the answer would be no. And in fact, looking at Chase, which is the primary case that Your Honors, that this court has issued back in 1991, talks about they talk about in sum the four elements for frustration of purpose. What was the main purpose of the contract? Has some event caused a significant change in circumstances that continued performance can no longer be achieved? 3, was the non-occurrence of that event a basic assumption of the contract? And 4, did the contract allocate the risk to my clients? And on 3 of those prongs of that test, the answer is clearly no. The main purpose of the contract was not for cleaning services. The main purpose of the contract was not frustrated by the COVID pandemic. The main purpose of the contract was back in 2015, my client sold its business, and all that was left to be performed was the payments. The purpose of the contract was to transfer an asset, and that occurred in full, and the only thing left to do was to obtain payment. The third part, the non-occurrence of the event was not a basic assumption of the contract. As I believe Justice Kafka pointed out when questioning my brother, this wasn't a situation where the performance of the business, there were no contingencies based upon the performance of the business or revenues or even the business being in existence. My clients had performed. All that was left was the payment. There was no force majeure clause. There, unlike Cafe Nero, there was no contingency in the language of the contract that said, we're offering this space, and the only thing you can do in this space ongoing is provide a restaurant with indoor seating that serves indoors. The purpose of the transaction was not frustrated nor made impossible by the COVID pandemic. And I think it's important to emphasize that while my brother characterizes the two individuals as guarantors and then attempts to pierce his own corporate veil, they were co-obligors. They were jointly and severally liable. And to the extent that the court might be persuaded that and I don't believe should be, but to the extent that the court might be persuaded that certain defenses may arise to the business, I would respectfully suggest that those defenses do not arise to the two individuals. There is absolutely nothing in the record, nor was it proffered by the two individual defendants, that the COVID pandemic rendered them unable to make the payments, that there were any defenses applicable to them, that the governor's mandates and orders applied to them individually. I mean, there is a reason that lenders and sellers require co-obligors in that sense, so that if something happens to one obligor, the other obligor is still on the hook. And they are not guarantors of obligor number one's obligations. They are jointly, severally, and independently obligated under the note. And if your honors have any further questions, I'm happy to answer them. Otherwise, thank you for your time.
SJC-13269, LaForte Enterprises, Inc., v. Lantern 18 LLC, and others.